Good morning. Are you Eleazar Stansberry? Eleazar, Mr. Stansberry, this is 26 DCCR 0174. You're charged with a first-degree felony offensive murder. Mr. Burbank, what is the announcement?
Filed a rejection. Today's charge, the offer was 40 years.
All right, let me go through that. So, Mr. Stansberry, what you're formally charged with is obviously the first-degree felony offensive murder, and that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions.
Nothing, as far as you know, not waiting on any type of discovery or evidence?
I think there's nothing that's standing out that is going to delay.
All right, so I want to make sure you understand also, Mr. Stansberry, that after today, I will not accept this agreement. The only reason I would accept this or something different or better would be because some different evidence or information came to light that your attorney and the state's attorney didn't know at this point. You understand? All right, we'll get it set on the trial docket. Mr. Burbank will be in preparation for trial.
I think that's it.
Yes, sir. Thank you.
Thanks so much.
Mr. Lewis, you have Brandon Bonton.
Yes, ma'am.
Brandon.
2, 3, 4, 6 cases. Good morning. Did I miss a whole page? I did. There we go. 1, 2, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court's file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, Your Honor.
At this time, then, I am going to find that Mr. Bonton is not competent to stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got the government microphone chip in my left knee, my right hand. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testified and take a lot of tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. So I go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
Mr. Bonton, you can go
shot that 45.
Go back with the bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial.
Sacrifice him, man.
That inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility.
No.
Well, a lot.
Y'all should have been back.
All right, let's see. Mr. Mr. Eckhart, you've got Mark Marceau,
Do Judge.
3 cases. Good morning.
Morning, Judge.
I think that needs to become a full case.
I'm gonna do it the right way. Very hard. Hey, can I go with my stuff, man? If they rather be murderers than rapists, though, like, don't keep their case, bro. But a brother, you a fucking nigga call me. Right. I gotta do your fuck, right?
Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau's charged in 2 of the cases with sexual assault of a child, and the 3rd with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the 2 kind of most urgent matters that we've got.
Okay. I don't see that request has been made yet for the CPS records.
And not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that motion and order, Your Honor, and also whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. And then we'll see where we are. But we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff.
If you want to look at the video this week, it's
Let's see, Mr. Brian Lane,
Yes, ma'am.
you've got Khalil Bradley Harris.
Yes, ma'am. That'll be a please.
I'll hold it till the paperwork's ready. And then what about Heyman Brandon?
If we may approach on him just for a second. Your Honor, the court allowed me some time.
Let's get Mr. Brandon out here. Since he's Heyman Brandon. Yeah, just hold on a second. Since he's here,
Okay.
let him know what's going on. All right, you're Heyman Brandon. And this is 21-36605. Mr. Brandon is charged with murder. And what is the announcement?
Your Honor, we're respectfully requesting one more announcement. The court has reset it today for us to get an insanity evaluation from Dr. Capone. It took me a little while to get to Dr. Rapon. I spoke with him yesterday. He said if I'll get him the materials, he could have an evaluation report done within 2 weeks. So if we could just have one more 30 days, I believe that's going to.
My concern is deterioration in our jail because we finally have competency after years of not.
Right.
And so I need that done. This is, I'm going to reset it 3 weeks. We need to have it done within 3 weeks. And so
I may be on vacation until the 15th. So
do you have a vacation letter in? Okay, we'll take that into consideration.
okay. Also, respectfully, if we get the report, I think the state's going to look at it. If the state wants to move forward, then we're going to ask for a bench trial. We want to set that in.
Well, let's see what the report says so that we know which direction we're headed once we get that report.
Oh.
So we'll just set it for an announcement, and then that day we'll know for sure what we're doing one way or the other. Okay? Sounds good. You can go back with the bailiff. Good morning.
Good morning.
You are Donald Cogdill,
Yes, ma'am.
and this is 26 DCCR 0005. Mr. Cogdill was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino,
I have, Judge.
any additions or corrections?
None, Your Honor.
Judge, obviously, I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony. And the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate, if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
There's something about parole, not parole, but like, I don't know. I don't understand what he was saying.
Okay. There's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house, and I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen, and the facts are that he was out. It started pouring down rain. He went to a house. He was on a back porch that he thought was vacant, and he was on the porch getting out of the rain. And 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up, and I got scared." And I mean, I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house. That's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but it was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for on the lower end.
Smallfino.
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, the There's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Go.
Baker.
Right out of the gate,
Jonathan-
the judge is doing something incredibly important here, creating a crystal clear legal record. Assaulting a peace officer is no small charge, and once the words 20 years in prison enter the conversation, the entire atmosphere in the courtroom changes. Suddenly, this isn't just another hearing, it's potentially life-changing. And this is where the case suddenly pivots. The second body cam footage enters the discussion. Everybody in that courtroom knows things could change fast. A defendant may feel confident rejecting a plea deal until they actually see the evidence. The real question now is, does the footage support his defense or completely destroy it? This is one of the scariest moments any defendant can hear in criminal court. Habitual offender status changes everything. Prior convictions can massively increase sentencing ranges, and now the defendant isn't just looking at a few years, he could be facing decades or even life behind bars. At this point, every legal decision becomes a high-stakes gamble. Notice how the courtroom dynamic shifts instantly here. The judge stops focusing on plea negotiations and starts evaluating competency. When a defendant struggles to stay focused or begins speaking erratically, the court has to determine whether they truly understand the legal proceedings. Because legally, if someone can't assist in their own defense, the case can't simply move forward like normal. This may be the biggest turning point of the entire hearing. Probation revocation cases often end with defendants being hauled straight to prison, especially after repeated violations. But instead of immediate punishment, the judge gives him one final opportunity to turn his life around. Still, the warning couldn't be clearer. If he comes back again, the outcome may be very different. Do you think he'll actually change this time?